Yeah, I think we're ready to begin. We're here this morning on our case number SA160051, Ernest Alvarado versus the Honorable Peter Thompson, with real parties and interests, Nicholas Murrieta, Vanessa Raquel Trujillo, and Yvette Alvarado. Each side will have 20 minutes. Petitioner will be responsible for reserving any time you'd like for rebuttal. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client when you approach the podium. We have read the petition response. We've conferenced this matter, and with that, we look forward to your argument.
Your Honors, good morning. My name is Spencer Schieffer, counsel for the petitioner of the special action, Ernest Alvarado. Today we're asking this court to accept jurisdiction and reverse the trial court's rulings that disestablish my client, the petitioner's paternity of the child at issue in this matter, as well as the order to change the child's birth certificate reflective of that change in paternity. Now, the trial court's ruling should be reversed because it erred in three ways. First, the trial court erred by incorrectly ruling, concluding that mother and the petitioner committed a fraud upon the court by signing the acknowledgement of paternity. At the trial level, the petitioner contested the fact, or contested the allegation, that he signed the acknowledgement of paternity with knowledge that he was not the father. He testified to the trial court of facts that he had a sexual relationship with the mother and that he was under the understanding that he may be the father of the child, and that he never took a DNA test to suggest otherwise, that he was not the father. Nevertheless, the trial court did find otherwise, that he signed knowingly that he was not the father, and that in so doing he and the mother committed a fraud upon the court.
We can't really look behind that very well, can we?
I'm sorry?
We can't really look behind that factual finding very well.
And I'm not asking the court to do that in this petition, but I do indicate that just so you understand the underlying facts. But fraud upon the court is a variety of extrinsic fraud, and what the courts have explained is that fraud upon the court is one of the most egregious acts and very rare. It typically involves attorneys, and in essence it prevents a party from having his or her day in court. It's explained as an intentional act that prevents another party from having a submission of the controversy. Now,
isn't that what happens with signing the acknowledgement of paternity? The statute says it acts as a judgment.
It does, but it doesn't prevent, and did not prevent, Mr. Murrieta from making a claim of paternity of the child. Under our statutes, Mr. Murrieta had the opportunity to make a paternity claim after he found that the mother was pregnant, which she told him, and he could have done so after the child was born, which fact he was made aware of, and even after the acknowledgement of paternity was signed and filed with Department of Economic Security, Mr. Murrieta still could have made a claim of paternity of the child. The signing of the acknowledgement itself did nothing to prevent his ability to make a claim of paternity on the child.
Well, there's a window of time where that's true.
That's correct.
But that window closed.
That's correct, Your Honor.
And your argument is, I think, that because the biological father didn't take any action, or those actions, one of those actions, during the 6-month period that the rules of procedure for family court apply, that he's barred, right?
That's correct, Your Honor. That's the argument.
But that doesn't answer, though, I don't think, whether the conduct constituted fraud on the court, which is a linchpin to determine whether biological father can press the claim now. And so I understand your argument, but it seems a little circular because I don't know that fraud upon the court requires that someone have had an opportunity to challenge something or contemplates that someone had an opportunity to challenge something earlier but didn't, and therefore it's sort of fruit basket upset day, recognizing fraud upon the court, unlike many other species of fraud, looks at least according to the cases, injury to the court itself, as opposed to injury to a specific party. That's why, among other things, diligence isn't examined in fraud upon the court, diligence of a party, because it's an injury to the court. So help me understand your argument on fraud upon the court. I understand your thought that there was a window that was closed and biological father did nothing during that time, and I think the record supports that argument. But I think what I'd like to hear from you is why, setting that aside, the action here was not fraud upon the court.
Well, I think it comes back to, Your Honor, the fact that even if they signed it knowingly, that petitioner was not the biological father, it doesn't injure the court in the sense that the court is not prevented from entertaining a claim of paternity of that child for someone else, such as Mr. Marietta, to come in and say...
And I understand that, but I think you're kind of fighting my hypo, and help me here, because I want to understand what your position is on that front. That goes back, though, to that 6-month window still being open, and it's closed. And it seems to me that either the argument is what happened here could never be fraud upon the court, or from your perspective, or that fraud upon the court just doesn't apply because you had this opportunity then and didn't take advantage of it. Or it may be both. I'm not looking to put words in your mouth, but I do want to understand what you're arguing.
I do agree with that line of thinking that it's going to be one or the other in any scenario. So if the two people that sign acknowledgement of paternity sign it knowing that the person claiming to be the father is not the father, it either is always going to be fraud upon the court or never fraud upon the court. And so I think the reason why it should not be deemed fraud upon the court is because that would allow the court to go back and change the paternity establishment under that statute at any time during the child's lifetime. There's no time limitation on that under Rule 85C. And there's a strong public policy that this court recognized in the Andrew R. case, that there is a strong public policy to provide permanency and stability for children. And that stability and permanency for any child whose paternity was established under that statute, 25-812, would be subject to upheaval at any time during that child's minority.
And I struggle with that concept as well. But let me ask you a hypo that's kind of a mishmash, not this case, not Andrew R., but let's say the biological father just didn't know anything other than he'd had intimate relations with a woman. Birth occurs, 6 months passes. Andrew R. says, hey, if you argue, I'll call it plain fraud, not fraud upon the court, too bad, it's too late. And unlike Andrew R., let's say there's no adoption or severance. So the putative father's registry doesn't come in play, and it doesn't really here. What is the answer then?
Well, I think the answer is let's look at our cases and our statutes that we have. I think it's no question that our statutes don't provide a lot of protections, but they do provide some protections for unwed fathers who give birth to children or who have issue. And under our severance statutes, we know that a father's or putative father's potential parental rights can be severed for things such as abandonment, which is defined as at 6 months, similar to the statute here of the limitation of no legal action to assert their parental rights in paternity. And we know from the Frank Arvey adoptions case that was issued earlier this year that a father can have his parental rights severed for failing to file a notice of claim of paternity with a registry, which is required to be done within 30 days after the birth of the child.
Severance moves quick, no question. And if there had been a petition to sever, then it would turn in. Putative father's registry talks about who is entitled to notice. And the biological father here would not have been entitled to notice because there is no registration, putative registry. Same with adoption. but neither of those two happened. So that statute sets forth good
Right.
policy for finality. I completely understand.
Correct.
But there's no claim that that statute applies here.
And I'm not arguing that that statute applies, but I think that those statutes and what the results of those are, that the courts have addressed, are instructive here as to why the result of, if a potential father does not make a claim within 6 months of when the child is born, because when the child is born, that's the soonest date an acknowledgement of paternity can be signed and go into effect, and that's what triggers that 6-month window. If a potential father takes no action to assert his parental rights, to take responsibility for that child, then whoever does and steps in, that the policy of the court is that we want to have, or the statute is we want to have permanency for the child.
And I understand that. What then's left of fraud upon the court, however you define that, be it broadly or narrowly, because it still exists. And at least as I read the statute coupled with the family court rules, it does contemplate that fraud upon the court could be pressed beyond that 6-month period.
It does and it can. What that looks like, I don't know exactly. What I do know in researching other cases in other states, California, for example, they had a very similar scenario in the case that's cited in my petition, In re William K. And in that case, the mother admitted that she intentionally kept the child from the father and had another man sign the acknowledgement of paternity to keep that child from the biological father. And the court in that case expressed that is not even extrinsic fraud, let alone fraud upon the court.
Which is fair, and there are cases from around the country that differ, including a fairly recent Vermont Supreme Court case that goes the other way. And California law, too, has something that I think Arizona doesn't, that to challenge an acknowledgement, the court has to expressly find that the ability to challenge would be in the best interests of the child. And only then, regardless of DNA testing, regardless of merits, regardless of timing, only if the best interest finding is made do you go to the merits. Arizona has no such provision that applies here.
I agree that it's the statutory framework is different and that the best interest part is not part of the statute. But I think it goes back to the public policy of the legislature to intend that we provide stability and permanency for the children in a swift manner.
Okay, so when you talk about public policy, you're putting the particular legal analysis aside just for the moment. The public policy of your position concerns me because if we say that this is not fraud upon the court, then as long as you have a willing mother and a willing male who will put his name on the acknowledgement of paternity, we have sanctioned an under the table and informal adoption. And I don't know how the circumvention of the adoption statutes is good public policy.
I agree that that concern exists. And the reason why I think it's not so much of a concern to find that the statute shouldn't apply, that this type of instance occurring is not fraud upon the court, is because it still allows for a 6-month window for a father to come in and assert his parental rights over a child.
If the mother is especially secretive, then the biological father is out of luck, and we have sanctioned. We in effect encourage de facto adoptions.
Well, the same thing occurs in adoptions where the courts have not overturned an adoption, such as the Frank R. v. Adoptions case. I mean, the mother in that case was very secretive and switched states and tried to keep the child, and the fact that she was giving up adoption from the father. But that didn't change the fact that he had to make efforts and comply with the statutes and filing with the registry.
Counsel, let me to follow up on Judge Howe's question. There is one thing, though, that didn't happen here that would have happened in the case you just mentioned and would have happened in every severance and in every adoption is there would be a best interest finding by an independent judicial officer. I mean, that's a requirement. Adoptions don't happen without that. Severances don't happen without that. But here, none of those things happened, and there was no best interest finding because one was not requested. There was no judicial proceeding. It was done extrajudicially. And you can envision, and I'm not saying that applies in this case, but you can envision some pretty horrible hypotheticals in that situation. How do we to take that the action that happened here really, prevented independent judicial best interest finding, which is essential, and I'm thinking of the Gama case, Supreme Court case in family law, case from a few years ago, and it was a special action called Bean, where the court said best interest just permeates in family court and in juvenile court.
Well, I guess the answer is that, if the legislature had wanted the court to go over a best interest analysis in deciding what to do with these acknowledgments of paternity that are attacked collaterally at a later date, then they would have included that in the statute. I guess what
and let me flip that around and get your thoughts on that as well, because as you can see, I do struggle with this. What wouldn't the legislative response be really to expand somewhat the putative father registry to deal with things beyond severance and adoption and adoptions, where it's limited now? I mean, the legislature, I don't think in its statutes in either Title 8 or Title 21 or 25 or even Title 14 contemplated the conduct that happened in this case. So you're right, the statute didn't say that that was required, but I think it would be a fair stretch for me to think that the legislature contemplated something like this would happen and just decided to do nothing.
Well, the statute's been in effect for, I think, 20 plus years, and it has changed over time. And as this court explained in Andrew R., that those changes over time were reflective of the legislative intent to more narrowly restrict the ability for people to collaterally attack voluntary acknowledgments of paternity. So I think I struggle with that too, and I think that if the legislature, in making those modifications over the years, this can't be the first time that something like this has happened, that they would have made that change if they thought that it was important enough. But I think what they've done in the statutory framework is that they've allowed for a potential father to assert fraud within a 6-month window of when an acknowledgement of paternity is signed, and that's reflective of other 6-month time periods when a father has to maintain or assert his parental rights. And so I think that the absence of it can also be viewed as the legislature's decision to promote that policy of saying, look, if a father's not going to come forward within 6 months of at least the birth at the earliest date, then he may lose out on his parental rights.
And that's even if he isn't aware of knowing when the birth occurred?
Well, that's not applicable in this case because Mr. Moreta was made aware that the child was born.
Is there anything to the notion that the child's rights may be implicated? And this may be maybe a bit of a stretch, but assume, for example, there's a case involving an inheritance, and by being adopted, the biological father, the child would have been entitled to inherit from the biological father. In that instance, we're not really concerned about stability for the child. The child's 17 or however old, and assuming there was fraudulent conduct, would it be fair to the child in that circumstance to say, nope, that was the biological father lost any rights to be the parent, and so you have no rights as a child?
Yeah, I guess that's an interesting scenario. I guess at that point what we're talking about is we're competing with two, I think, good policies of one, promoting stable families versus promoting, potential inheritances. And I think the former is more important overall, that we not leave open-ended the ability to disrupt the family unit and disrupt a child's stability with who that child knows to be his or her father, for however many years it may be, 4 years in this case, and to disrupt that, based on the potential that there may be something like that of an inheritance down the road. And last thing I just want to touch on is, with regard to the motion to set aside that my client filed, even if the court doesn't agree with me on the legal arguments that I presented in my petition and that the trial court erred, we still ask that this court reverse the trial court's decision to deny that motion to set aside. In a nutshell, what happened was in January of this year, the mother stepped forward and spoke to the petitioner that she had been coerced into not participating with the proceedings, and thereby she was not present and did not provide testimony at the November 9th, 2015 hearing. The trial court, I think, recognized that the facts of this case, including the facts surrounding her sexual relationship and the nature with her communications with Mr. Marietta, were imperative in the court's decisions, and so I think it was a denial of justice and abuse of the trial court's discretion to deny that motion. So if nothing else, we'd like to have a hearing where a mother can be present and not be coerced and provide her testimony to the court. Thank you.
Good morning. May it please the court, my name is Attorney Douglas Gardner. I represent Nicholas Morietta, who's present in the courtroom, and he is the real party in interest here today and the biological father of the child that we're discussing. The primary issue in this case comes down to constitutional due process notice to my client. One of the things that I want to have the court look at is while this is not an adoption, it's important to contrast what would have happened if an adoption would have occurred. And so in ARS 8106, this talks about the difference and the distinction between a parent that would be required to give consent to an adoption and a parent that would be required to be provided notice. The putative father registry, you must register if you want to be able to give your consent. But if you don't register, that doesn't mean you're not required to be given notice under the constitutional due process requirements, nor under this statute. If you look close at, again, ARS 8106, F, G, and I, it specifically talks about that notice that, well, F, mother has to file an affidavit naming any possible father. G says notice shall be served on each potential father, not only those that are registered, but notice needs to be provided to all of them. And then I says the notice has to include the following language, and goes through and includes very important language that must be in there, including I-11, you may wish to consult with an attorney to assist you in responding to this notice.
Why is due process implicated here where there's no question that biological father was aware that there was a child and could presumably have filed a paternity action?
He was aware that there potentially was a child, and then he was then told that the child had already been adopted, and it was therefore too late for him to do anything about it. But then the due process and the notice requirement come in that if this court is being asked to affirm orders and hold him that he can no longer come in and challenge those orders, he's never had an opportunity until recently to present his case and to present what he thinks is the best interest of the child and to address these issues.
Well, because he knew about the pregnancy, he knew about the birth, and I understand that the mother said that the child had been adopted, but that didn't prevent him from instituting an action to establish his paternity and interest in the child, and he didn't do that.
Well, case law is pretty clear that once an adoption is done and the 15 days to appeal are passed, it's really hard to set aside an adoption.
Well,
this would be a very different case if that had happened. And then to your point, then, if he would have had if he would have tried to file that proceeding, one of the things he would have had to do is serve the mother. As was testified in court and as the judge found at the trial court level, mother disappeared and ceased any communication with him. So he would not have had the opportunity to serve her because he couldn't even find her. So that would not have been possible to happen.
Counsel, let me ask you though, and to use as an analogy, some severance case law. And,
Sure.
and severance didn't happen, adoption didn't happen either here. So
a very different case if either of those would have happened.
we wouldn't be here, frankly, if either of those happened soon after the child's birth. But they didn't. And the case law, which speaks about actions that unwed fathers need to do, is to do something. And one way of looking at this record is that your client learned of the birth of a child that presumptively either was or could have been his, was told something, and then did nothing for 4 years. So I understand your due process argument, but it strikes me that, you know, the test case would read somewhat differently than it does with respect to due process concerns. I'd be happy to hear of your reaction to that, but I'm also interested in the fraud on the court discussion as well.
Let me see if I can hit both. First of all, had a severance or an adoption been filed, my client would have been entitled to service of a summons or a notice or something else, which would have said you have a right to an attorney or you need to hire an attorney, would have been a legal proceeding. If either of those had been instituted, at that point he would have known where to serve the other side. He would have had an opportunity. He would have had a forum, a legal forum in which to have the issue ruled upon.
Let me focus just, and I know I'm interrupting you by doing this, but your point was father didn't know how to serve mother. Well, there are fixes with that if legal proceedings are initiated. So I guess the thought that that couldn't happen, first of all, it's a hypothetical, and secondly, it doesn't persuade me very much because the short of it is nothing did happen until many years later.
If I could just follow up on that, why is this different than if someone owes a debt, you know there's a debt out there, I mean, it doesn't, because the person has moved, wouldn't necessarily keep you from pursuing a claim to make sure you get a judgment if there's a statute of limitations at some point. The fact that you can't find the party that owes you money right now presumably would not keep you from getting a judgment so you can enforce it when the person is found.
Now, service by publication would be available for the debt, not really applicable if you're fighting over the custody of a child, because if you can't locate the parent or the child, that judgment's not going to do you a whole lot of good at that point. And so the difficulty here, and one of the things that again, if you look through the transcripts of the trial, we address this. I mean, this is my concern here in this case, and we address this very much with the court of the steps that my client and his mother and other people in his family took in trying to locate the mother and trying to find her. And bluntly, she was not to be found until the divorce between the father and the quote-unquote father and the quote-unquote mother happened, and there was some anger between the two of them. My client was then informed where the child was. He had not been able to locate the child. He did make some diligent steps to find them. This would be a better case for us had he filed something with the court. I'll agree to that. But he did make very diligent steps to try and locate the child and the mother, and was unable to do so because she cut off all contact.
So on the issue of fraud on the court, the thing that I struggle with is when the acknowledgement of paternity was signed, the court was not involved. So there may be fraud, and I suspect there more probably is fraud, but whereas on the court side of the fraud on the court.
The way we get there is simple in that the statute says that the acknowledgement of paternity has the same effect as an order of the Superior Court. And so by signing an acknowledgement of paternity, you are then getting an order from the court, the Superior Court, that says you are the father. And so if the parties had to go in and sign an affidavit before the judge, and the judge would then sign that, have the same effect as a order of the Superior Court, they would have to go in and make some affirmation to the court, which then is the fraud in this case, because he's not the father and he wasn't the father.
And forgive me, I'm not trying to slice things too thinly, but is a document that acts like a judgment the same as a judgment and the same as involvement of the court? What is the injury? In essence, we're focusing on the injury to the court, not to the parties. what is the injury to the court by the signing of an acknowledgement of paternity?
The injury would be the same. If the parties came in and signed something, a stipulation, and the judge then accepted it and signed it, or if, in this case, they signed the acknowledgement of paternity and by statute it has the same legal effect, the judge is then precluded from, as to those two parties, precluded from changing or altering that judgment. That judgment then is entered subject to appeal and whatever else. So by the judge signing it, that issue is then res judicata, it's taken care of. Now, the concern we have, and the reason we have to look at it exactly the same as if a judge had signed it, is because in this case we have somebody who was not a party to that case. Now, the acknowledgement of paternity was signed by the two parties and involved the judge more in a legal fiction way because the judge never needed to sign it, but it has the same legal effect as if a judge signed it. So it involved the two people on the acknowledgement of paternity and the judge. And now, because we're trying to come in and challenge that, then the legal principles at issue are the same as with issue preclusion or claims preclusion, that the parties to that case can't come back in and challenge it after the fact. But parties who were not a party to that case, parties who were not involved in that case, certainly would still have the opportunity to come and make that challenge.
Is there a fraud on the court anytime a birth mother who has a pretty good idea of who a father might be, when the birth mother alleges, I don't know who the father is that a fraud on the court if they make that statement, having a pretty good idea of who the father is, but not listing one?
That would certainly make this a greater case, and that's why in a very important finding that we presented evidence and asked Judge Thompson to find, and he found was that they knowingly signed this, knowing that the person who was signing as a father was not the father. I think that distinction is important.
Is that? Let me pick up on that. Is that, though? I worry about if fraud on the court occurred here, and this is to follow up on Judge Catani's most recent question and the question of petitioner, what is the bound? What is the time limitation? You've got really three limits. The 60 days where you can rescind. Well, that doesn't apply in any stretch. The 60 days, or I'm sorry, 6 months that we've talked about and that Andrew R. expressly addressed, although with a somewhat different rule set, but the same concept. And then fraud on the court, which doesn't appear to have a specific time limit. What is the bound? I mean, let's say some of this came to light when someone's 30. Does that mean that all this kind of dust up can happen then, especially given the policy to get permanency soon in so many different ways when we're talking about young children?
I don't think the legislature has given a bound, and it would be for them, not me, to say where that bound would need to be. But the catch for that, or the prevention for that, or the concern for the child, which has to be paramount in these cases, the best interest of the child, is with the trial court in needing to make a finding of what's in the child's best interest. And in challenging an acknowledgement of paternity, whether inside the 6 months, whether inside the 60 days, whether inside 4 years, the trial court still has that obligation to look at what's in the best interest of the child. So if you have a 16-year-old child and similar case, and the person, the biological father coming in is a registered sex offender, and let's imagine the worst. The trial court could say, yes, you've proven to be the biological father, but you've not proven that it's in your best interest, in the child's best interest. And I think the trial court would still have that discretion to avoid the concerns that you're outlaying and saying, well, wait a minute, why can't we have a statute limitation or some kind of limitation on this?
And I mentioned that my recollection was that California, by statute, requires that before, that's the first question, is allowing a challenge in the best interest of the child. And if the answer is no, you stop. And if the answer is yes, then you go to other things. Is it and there's no case that we are asked to sort of use as a guide other than Andrew R., which answers some of what we're asked to look at, but anticipates this case in in a pretty amazing way.
The dissent in Andrew R.
Well,
anticipated this
and
case.
even the majority, though. But there is no, as I mentioned, there's no best interest statutory directive in this context because there's no statute in this context. There's statutes all around it. But does the best interest requirement that you've just laid out come from the bare fact that this is a Title 25 or a Title 8 proceeding, or is it from some other origin?
And I wish I'd come prepared to specifically state that, but when you're looking at when you have an acknowledgement of paternity, the process to set that aside does contemplate that the court can order biological testing, and then does indicate that the court has to do the best interest afterwards, different than California. It sounds like California, they have to do that first. But that would be somewhere in 812, but it's two pages long, and I'm not sure you want me to read through that, but it is in ARS 25-812 does contemplate and require the trial court in an acknowledgement of paternity case. So I guess if we change the facts here a little bit and say that my client no longer exists, but somehow it's proven that there was a fraud upon the court, that doesn't necessarily mean that the fraudulent father, quote unquote, would not be able to be recognized by the court as going forward, still being the father in that case. The 812 does acknowledge and does allow for someone who's proven to not be the biological father to continue to be the quote unquote father, again in the best interest of the child. So that is the best interest of the child is protected with statutory framework, and is a very important part of what we're arguing. I mean, I agree that this should not just be purely DNA test without any further judicial consideration in this type of a case. The other issue I'd want to bring up is that the argument for tolling the 6 months still is very applicable. Now, Andrew R. talked about it in the content of the two parties and said, no, that you can't have the tolling in that case. But I think the distinction is because they were parties of the case. All the law we have on issue and claims preclusion, the res judicata principles, it is a denial of the due process notice to the parties if somebody who's not an interested party in the case does not have an opportunity to file a pleading, a response, does not have an opportunity to put on witnesses and bring in exhibits for them to be then have a judicial determination where they were not involved held over them, and they simply are not able to do that. And so the tolling language that Judge Thompson used at the trial court level would be applicable in this case or in the case of the hypothetical that you gave of the child who's now 17 or 30 and wanting inheritance, for him to be able to come in and say, hey, I was not a party to that case, a judicial determination.
Could I ask, when we're talking about the best interest of the child, in your view, does the woman who raised the child for 4 years or however long, under either scenario, does she have any right to to parenting time under any scenario?
Let me, and perhaps inappropriate because I'm telling you what's happened after the litigation that's actually before you, but as of January, the child is now living full-time with my client. We have been able to, before judicial intervention, we were able to reach an agreement with the mother who raised the child for 4 years, and we were able to have her come in and have some third-party visitation time, similar to grandparents' visitation time or step-parent visitation time.
But is there any legal entitlement to that for?
There is, I believe so, yes. And then since then we were able to go in back to the trial court and in lieu of temporary orders reached an agreement with the
what's the
paternity
legal
father.
entitlement? I'm trying to. I don't mean to suggest that it's in any way a negative that something has been arranged. But is there what would you say the legal basis for her to assert parenting time?
Yeah, and it wouldn't be parenting time because neither the
Or in loco.
it would be the in loco parentis or the third party parenting under ARS 25-8. I'm sorry, 410 or 411. They just recently moved that about 2 years ago. But yeah, we readily acknowledge, because they have a 4-year relationship with the child, that, again, based on the trial court's determination of the best interest of the child, they need to maintain that relationship, and that's healthy for the child to have that.
But Counsel, I have no doubt that that's an appropriate.
I'm sorry, 25409 is the statute that talks about third-party rights, and because they have that 4-year relationship with the child, they do have a legal right for that, and I apologize.
And what I was going to ask, though, is that's an appropriate resolution here, but my question is that the mother who raised the child is really nothing more than the equivalent of a stepmother here, and what are the rights of step-parents?
Now, that's a very interesting question within the confines of this case. I mean, because there are 4 parents, there's a biological mother who's never had anything to do with the child since birth. There's the couple who divorced that raised the child for 4 years, but part of the reason my client was even given notice is because the father was refusing to let the mother have any time with the child, and so mother then came, that stepmother came and let my client know, oh, by the way, you're the father.
But I just wanted to focus on the exact same question, just in terms of, let's just say it's someone who comes to the marriage with children, with an infant child. Mother helps raise the child for 4 years. Arguably, in the best interest of the child, mother should have some time. But does mother have any right to that?
I believe so, under 25409. It does contemplate both third-party rights, which would be, it used to have it separated out, grandparents' right versus other, which would be the step-parents. They've now consolidated in. But yes, I believe so, and in this case and in a broader hypothetical, yes. So, judges, thank you.
We'll add a little bit of time, and if anyone has any other questions, I didn't mean to cut you off at all. Why don't we put 2 minutes on the clock for your rebuttal?
Thank you, Your Honor. Just a couple things I wanted to address, some concerns. With regard to Mr. Murrieta's ability to file an action, in his testimony, he was asked if he asked mother where the child was and who adopted the child, and he said no. So he made no inquiry to mother about where the child's whereabouts were. And then in his testimony, he was asked why he didn't hire legal counsel and why he didn't file an action. His response was he didn't know he had a child, which is contrary to his own testimony, where he admitted that mother told him that she was pregnant and the child was likely his. And Mr. Murrieta, I think, is different than other fathers in other cases where they took efforts, even where the mother in that case made deceitful actions, like in the David C. versus Alexis S. case, where the mother changed states and cut off contact, and he didn't know the child's name or the exact date of birth, but he took action. He filed a paternity action. He tried to take efforts to find that child, which he ultimately did, and was ultimately able to overturn that adoption in that case. Now, as far as best interest goes, I did just a quick search, and I don't believe the term best interest is anywhere in 25812. So I don't think that statute contemplates any kind of best interest analysis under that statute.
And that may be, but doesn't GAMA sort of say, hey, in family court generally, when you have children, best interest is in the courtroom somewhere?
I think so, but I think that case is narrowed down to the idea that we're not going to uphold discovery sanctions and keep out documents that may be pertinent to the child's well-being, because in that case, clearly best interest did need to be addressed, not for the sake of generally, but for that case specifically.
Can I go back to kind of the question on a stepmother, and in this case, assuming the court were to say biological father just had no rights to do anything, he was too late, does mother who's raised the child have any right to time with the child?
I think she does, as long as she meets the statutory requirements. I think Mr. Gardner's correct that the statute is 25-409, which is a couple aspects, one of which is in loco parentis visitation for third parties. And that falls under a broad scope. It doesn't have to just be step-parents. It can be a neighbor even under the scope of that statute. But the stepmother in this case may be entitled to that as long as she meets the statutory requirements set forth in there.
All right. Thank you both for your arguments. We will take this matter under advisement and issue a decision in due course. And with that, we are adjourned.